Commonwealth versus Cruz.
Mr. Keene?
May it please the Court, Benjamin Keene, Committee for Public Counsel Services, on behalf of Hector Cruz. This is an appeal from the defendant's conviction of masked armed robbery of a convenience store. The defense was misidentification. The Court transferred this case from the appeals court sua sponte. Allow me just to very briefly sketch the facts in this case in order to put the two identification issues in context. This robbery of a convenience store was videotaped. The videotape was shown to the jury. It took less than a minute. The robber's face was almost completely masked, covered by a mask of some sort, including the robber's head by a hat, so that all that was visible to the victim, the employee of the convenience store, was the robber's eyes. 6 days after the robbery...
But he heard his voice, correct?
He heard the voice of the robber. Yes, there was a threat going on during the course of the robbery. 6 days after the robbery, the victim went to the police station.
Just for completion of the facts, as the robber left the store, he stopped and took some cigarettes.
Correct. And the victim testified that two things. He testified, he went to the police station 6 days later, said he believed he had recognized the voice of the robber as a customer who frequented the store, and that this belief in his mind was solidified by the fact that the customer whom he had in mind would buy Newport cigarettes, and the robber seized Newports during the course of the robbery.
Since the defendant contended that he didn't come into the store often, I think the defendant claimed that, and that therefore the inference is that the clerk wouldn't know him, then wasn't it probative to show that the clerk could pick out 5 of the defendant's photos from 1,300?
No, it wasn't. The defendant didn't say that when the defendant testified to his alibi, he disputed some of the victim's testimony about the frequency, but it was undisputed. After the victim goes to the police station, selects 6 photographs, not of the face of the robber, because he didn't see the robber's face, but the face of the person whose voice he believed he recognized. The warrant issues, the defendant is arrested on the basis of that, and upon his arrest, he vehemently denies, says, I didn't rob the store, I frequent that store, I know the employees. So it was undisputed in the Commonwealth's case, A, that the defendant was a customer of the store. It was also undisputed that the victim believed that the robber was the defendant/customer.
But how well the victim knew the defendant might go to how well he would know his voice. I mean, would go to how well he knew his voice.
And the photographs had nothing to do with the voice.
No, but it shows that if you see somebody, it shows familiarity, that I've seen this guy a lot. I can pick, out of 1,300 photos, that's a lot, I can pick him out every time.
That fact could have been testified to.
Was there evidence that the victim picked out the defendant's photo every time that it appeared in the 1,300?
I think it's a little ambiguous on that. The evidence is that he picked out, he looked through the database. There were 1,300 or so photographs. The defendant's photograph was there at least 5 times, and he picked it out correctly. But
did you request a voice lineup?
No, and the Commonwealth, of course, that wasn't the defendant's burden.
But
that should have been done in this case. That would have been interesting. That would have been probative if there had been a voice lineup. After the Commonwealth could attach a name to the customer who the victim had in mind, then, of course, there ought to have been a fair voice lineup procedure to see whether, in fact, the victim could reliably identify the voice. Instead, the case was prosecuted on the assumption. Once you realize this flaw, this case becomes a miscarriage of justice, quite likely. It was prosecuted on the assumption that he had reliably identified the voice of the robber as pertaining to the defendant.
But you can point that out over and over in an argument or in questioning.
Well, that's where the error comes in. The photographs, the Commonwealth argues, and I'll try to state the argument as fairly as I can, that the victim's ability to select the defendant's photograph 5 separate times goes to the reliability of his belief that the robber's voice was that of the defendant, a regular customer. Now, when you focus on that, the voice identification, it seems to me that that argument defeats itself. It holds zero water.
But that's not quite right. I'm not, Commonwealth can articulate its own theory, but as Justice Cowan was suggesting, it also goes to the I can't pronounce it, how familiar your client, or excuse me, the victim was with the customer. I mean, I take it 5 times picked out. It wasn't the same photo 5 times.
No,
different hairstyle, different clothes. I mean, that this was a face that was quite familiar, and that sort of is relevant. I don't know how that's not relevant to voice ID.
It would have been relevant if he had seen the face of the robber, had given a description of the face of the robber, and then had picked out a photograph that may or may not have resembled his description of the face of the robber.
Well, gee, if you see someone once a week, see them, make a few casual remarks to them, or hello, how are you? But if you see them every day, you're going to be more familiar with their voice because you see them every day than because you see them once a week.
I totally agree, but the photographs had nothing to do with testing that proposition.
Well, it does, because it says that to pick out some of these 1,300 pictures are a lot of pictures to look at, it seems to me.
But they don't say anything about the voice of the person whose photograph he picked out.
But they show that this victim is at least quite familiar with the person.
Which was conceded, which was not...
Well, it wasn't conceded.
It was
because
undisputed.
The defendant argued he hadn't seen him in the grocery store or hadn't had that altercation with him in the grocery store just a couple of days before. So it wasn't conceded, at least to the degree that the Commonwealth...
That's true. There was a dispute about the degree of familiarity, but the victim's ability to repeatedly say, yes, this photograph, this mugshot is the defendant, this mugshot is the defendant, this mugshot is the defendant, doesn't incrementally prove familiarity with the voice. And that is the gap that was at the trial and here.
Mr. Keene, maybe I'm missing something, but I thought the suggestion was that the victim makes a voice identification, which in his mind links the robber to a particular person.
Correct.
He then goes through
Right.
photographic arrays and says, "This is." So it's a little bit my hearing your voice. You're completely masked and so on and so forth.
Right.
I can see only your eyes, but I recognize your voice.
That's right. And the purpose of the looking at the mugshots was to identify the customer whose voice he believed had been the robber. So I think when you look at it, it will become clear that...
So what you're saying is, if, for example, I believe that this is Keene...
The way to test that...
But in fact, it isn't. For me to look at 1,300 or 2,000 photographs, and each time I pick out Keene, it doesn't do anything.
It proves something that is not disputed, correct.
All that it says is, I, as the victim, believe I heard Keene.
Precisely so.
It also might show that you know Keene pretty well, if you can pick him out from lots of different settings and in lots of different...
Well, that's the point that I would just... There certainly is. Maybe that's true. Maybe it's not. But in any event, the relevance of the mugshots in this case was minimal at best, given the victim's inability to see the face of the assailant and his unequivocal testimony that he believed he was making, identifying the customer on the basis of the voice.
Would you dispute the Commonwealth's ability to introduce one of the mugshot photographs?
Well, I wouldn't, because that was conceded by the defense counsel below, but it is a little logically inconsistent with the argument we're making. I think what realistically happened here at the trial, the writing was on the wall. The judge was going to allow the Commonwealth to introduce these photographs, and he tried to minimize the damage by saying one would do it. One certainly would have done it, but logically the answer is no. The testimony of the victim itself would have been sufficient to explain how the defendant's name got on the arrest warrant.
Did he, Mr. Keene, did the victim say, well, I suppose he wouldn't have known Mr. Cruz's name,
right,
correct?
He did not.
So he didn't say, it is Cruz.
Right.
It was, if you showed me a photograph,
precisely,
I could tell you what it was.
That's how it happened.
So what you're really challenging, it seems to me, at base is whether or not on the basis of a voice, whether or not on the basis of a voice identification that is sufficient for the Commonwealth to identify a citizen and...
Yes, and that goes back to the
Well,
point.
aren't we forgetting about the cigarettes? Do they have no significance whatsoever?
Well, I don't find them very persuasive. I mean, how many people smoke Newport cigarettes? It's interesting from a victim psychology point of view, because he testifies that was the sort of what clicked in his mind. Aha, Newports, it's
No,
this
Voice
customer.
Plus cigarette, a particular brand.
Okay, let's look first at the voice. The Marini case makes clear that voice recognition is notoriously unreliable, and there was no attempt to even do a voice lineup. So then if you want to add to that the Newports, is it worth nothing? No. But does it make this a solid voice identification? I think the answer to that is self-evident. There are...
On the issue of the mug shots, didn't the jury know anyway that the defendant had a criminal record?
Yes, they
So why are
found
the
out.
mug shots then even an issue?
Well, because...
I mean, they were sanitized, the judge gave the instruction, but
Right.
aside from that...
They were obviously what the jury was going to infer, that these were mug shots. And the Commonwealth argues essentially harmless error because he testified and was impeached by his prior record. Two problems with that argument. Number one, if the mug shots had been excluded, as they ought to have been, the defendant may well not have chosen to testify and open himself up to this impeachment. So one can only speculate as to this harmless error analysis. It's far from clear, contrary to the Commonwealth's argument, that the defendant was going to testify to this imperfect alibi and open himself up to impeachment. And the second, the Nassar case, which is 351 Mass at 45, makes this point, that the defendant's record would have been admissible to impeach his credibility, but we can only speculate on whether he would have testified if, in this case, the photographs had been excluded. The second problem, of course, is that we have impeachment by prior conviction plus 5 mugshots, sanitized or not. What this does is paint the defendant as a career criminal, a person
but how does impeachment by prior conviction, how is that worsened by mugshots? The jury knows he has a prior record. He's been arrested. His mugshots taken.
Well, it's both of my arguments. One, he would not necessarily have been impeached because he would not necessarily have opened himself up.
Well, I understand that argument, but I was just addressing myself.
Well, it's 5 run-ins with the law for each of the mugshots that were unnecessarily introduced, plus the prior convictions. They might have said, well, one photograph goes with one conviction, but the overall picture one gets from this case is that the defendant was presented to the jury as a chronic person in the...
One other question. I'm sorry, go ahead.
Could you talk about the request for the jury instruction?
Yes, I do want to turn to that.
I was going to ask you on that subject. Did you present the judge with the modified proposed jury instruction you've now given us in Note 4 of your supplemental brief? Did you give the judge...
Is that the voice identification?
I forget.
I don't believe so. In the supplemental, in the reply brief...
It's on page 10.
Counsel, my colleague, Mr. Obligato, focusing on what was really the missed issue here, the voice identification, suggested to the court what would have been a fair voice instruction. But no, the instruction in issue here is the instruction from Santoli, based on Santoli, that the jury ought to have been instructed in accord with undisputed social science and behavioral psychology, that in some form or another, that the confidence with which a witness expresses an identification is not necessarily correlated with the accuracy of that identification.
No, but my question was Note 4 on page 10. You didn't give that, you didn't suggest to the judge that modified proposed one. Okay.
No.
Why,
That's the ear witness. Yeah, right.
why wasn't the instruction that the judge gave on an honest but mistaken identification sufficient?
Because it's a very different point. The Presley instruction, while salutary, points out to the jury that a eyewitness need not be a liar in order to be giving incorrect testimony. But the instruction that was requested focuses more on, exclusively on the degree with which the witness expresses certainty. And there's 2 reasons why.
That would be a new rule, wouldn't it?
it would be an extension of what this Court said in Hyatt and Santoli. Let me read this. We recognize that based on a trial record or on the published results of studies or both, some new principle concerning the process of eyewitness identification may become sufficiently reliable so as to justify formulating a jury instruction that should be given in particular circumstances. It's true, it has not been heretofore required, but it has...
In fact, we said if you go to the very end of Santoli, we said you don't give any jury instruction.
Well, I think you say you omit the flawed language that reinforced the fallacious assumption, and this is why this is particularly important in all kinds of identification cases, because not only is accuracy and confidence not correlated, it turns out, but that jurors believe just the opposite, in fact.
Well, I mean, even were I to agree with you, Mr. Keene, what am I to make of a relatively recent decision that says, in the future, however, the significance, if any, of a witness's confidence in an identification should be left to cross-examination and to argument of counsel and should not in the normal course be a subject of a jury instruction. I take it that what the Court is saying, it's okay for the prosecutor to argue this is a very strong identification. So you are saying not only is that impermissible, but there should be an instruction.
We are not saying it's impermissible because there's too much water under the bridge there. The Court has repeatedly said that this sort of argument, even though it is not substantiated by the social science research, is permissible. But given the fact that juries are going to be given this overweighted argument, it should be tempered by an instruction that accurately focuses on what the reality is. We do not normally permit jurors to decide cases on what we know is misinformation.
Especially why would we allow prosecutors or defense counsel, for that matter, to argue to that? In other words, if the science has developed so that we now know, clearly whether we do, but if it has developed so we now know that the strength of identification has got absolutely zero correlation to the accuracy and may indeed be misleading, why should we allow a prosecutor, as we appear to have done, or defense counsel in a different kind of case, to say, you know, this witness told the police day one, this witness never wavered, this witness was shown 1,300 photographs, this witness only selected this victim. You know, in all of my years, I have never seen a clearer, more forceful and stronger identification.
And that's exactly what was done in this case. The prosecutor, I know my time is up here, dramatically finished his direct examination of the victim by saying, is there any doubt in your mind that that man in the videotape is this man right here? If anyone has tried an identification case or prosecute, you know how difficult it is to meet that kind of argument. It was then stressed to the jury in closing argument. The ID is reliable beyond a reasonable doubt because the victim was confident. And I agree that that is troublesome when you look at the social science, permitting that kind of evidence to come in. But at the very least, we should temper it with an instruction that warns juries, counter to their instincts, to not give undue weight to that, because it is a direct source of erroneous convictions. And if you look at this case, you look at the videotape, which is perhaps not presented, once you realize that all that links this defendant to the crime is the victim's belief, that untested belief that he recognized the voice as the defendant's, one hardly feels safe that this is a proper conviction.
But you can't say it's untested because he was cross-examined on it, I assume. I haven't read the transcript, but I assume there was cross-examination on it.
Regarding
his voice identification.
He was cross-examined. Yes, he was. But it wasn't – there was no lineup. There was no voice lineup. Of course he said, I'm sure. Yes, that's – but he never actually was asked to listen to the defendant's voice under any circumstances and then compare it to the voice that he remembered as the robber's. That is the substantial risk of a miscarriage of justice in this case. I see my time is well over. Thank you.
Ms. Grant.
Thank you. Good morning. May it please the Court, Assistant District Attorney Cheryl Grant from Middlesex for the Commonwealth. As an initial matter, I would just submit that the defendant did not raise this issue regarding a purported voice lineup at trial. It was not raised until the reply brief. and I would submit that that issue should be waived, and in any event, this isn't typically the issue of a voice lineup. There was a case, Commonwealth versus Lutz, which I cite, where that issue typically arises where some type of voice lineup was done, and there is some suggestiveness in that lineup. And as a result of the suggestiveness, because a defendant has a due process right that a lineup, when conducted, be conducted properly, that when that's implicated, that is the situation where something like that is appropriate. Here, that didn't happen. Mr. Patel here, the victim, the clerk in the store, testified that when he heard the voice, he recognized the voice as belonging to a customer who frequented his store over the period of approximately the previous 6 months, almost every day, and that he spoke with him every day, that this individual was an Hispanic man. He also gave the estimate of his height, and when which can also be seen on the videotape, not only did he say he recognized the voice, as well as lynched with the fact that he took the same type of cigarettes that this individual bought on a consistent basis, the height was also consistent with the customer's height.
What was the victim, what was his native tongue?
There was a reference, I believe, during a sidebar that it was believed he was Indian. Mr. Patel. There was no direct testimony. That was the belief of the prosecutor at the time. So it's not definitively clear that that's what his ethnicity is.
But the voice that he overheard was speaking in English?
Yes, the voice was speaking in English, and he indicated that it had an Hispanic accent, and was saying things when the individual came in.
I think the defendant quibbled with the fact that there was no testimony that the victim stated that it was a Hispanic accent.
He takes issue with the second person that came into the store. There was an individual, Mr. Jamie Gavlik, who also entered the store, and he was the subject of one of the second complaints they saw with the dangerous weapon. And at trial, initially there was a belief that he had supposedly told the police that he thought it was a white individual. And he testified that the police report was actually wrong, and that what he told the police was that I said that it was not, speaking of the accent, was that it was not someone of that it sounded to be white, it was someone more of Hispanic in terms of talking about the accent.
What about the victim?
The victim specifically said that the person spoke with an Hispanic accent.
I take it in this case, the defendant did not offer any expert witnesses or expert testimony on voice identifications and their unreliability.
That's correct. There was no, it never arose, it was never requested, there was no issue of the expert.
Would you agree with me that this would be an appropriate case for such testimony?
Well, I believe that there are cases where it can be appropriate. I know it's been, in terms of expert testimony, it's in the discretion of the judge. And I think one of the issues here, which is sort of all ties in together, is with the 5 photographs. The level of familiarity of the individual identifying the voice is directly and highly relevant and probative to whether that individual correctly identified the voice.
No, because if I think it's your voice, in good faith, I may be mistaken, but I think it's your voice, and then somebody shows me 1,300 photographs, and each time I pick out the photograph of you, because I know you've come into the store a number of times, so I probably know you in different kinds of dress, and I know you in different, hairstyles. I mean, I've seen you a lot. And it goes back to the first, that really isn't going to help me with the identification. All that'll tell me is this is a customer that I've seen many, many times. And I think it was undisputed, is it not, that the customer had been into the store many times?
The fact that the defendant admitted he had been in the store, he did dispute the fact. He said that he had barely ever spoken with Mr. Patel.
No, not spoken, but that he had been into the store a number of times.
He didn't dispute that he had been in the store a number of times, but those are also important factors. Here, where it is a voice ID, the defendant disputes aspects of Mr. Patel's testimony. He disagrees with the fact that he spoke with Mr. Patel on almost a daily basis, and also claimed that he was not the individual who had argued with Mr. Patel at the market basket approximately 10 days before. So in essence, you have the defendant claiming, well, yeah, I was a customer of the store, but Mr. Patel, he's describing somebody else entirely.
No, I understand that, but what I'm saying is if I have decided that it's you, and I don't know your name, but I know what you look like, the fact that I can pick photographs of you out 5 times it doesn't tell me a lot about the initial identification.
Well, it does tell the familiarity. With the picture of the individual he was picking out, he specifically said, is this individual that I spoke with on nearly a daily basis who bought these cigarettes and whom I argued with at the market basket. And when he picks out the photographs, it is directly tying it with those instances. I'm not arguing that that's the end-all and be-all of the case, but it's certainly probative of the level of familiarity.
So if there were 1,000 photographs, you could introduce 1,000 photographs?
No,
Of you.
that is not the
Of
instance.
the, yeah.
Right, so there were 5 photographs which are different, in which this individual appears differently, and it certainly is relevant to showing that this individual, Mr. Patel, was in fact so familiar with the defendant that he could pick him out 5 separate times out of close to 1,300 photographs.
All that that tells me is that this is somebody that I can recognize in 5 different, from front, from back, from side, from top, with wearing glasses, not wearing glasses, short hair, long hair, with mustache, without mustache.
Correct. Again, it goes to the level of familiarity of the witness, which I would
But then
submit
you're
is
asking us
relevant.
to translate that into familiarity with the voice, correct?
Correct.
Okay. Was the strength of the ID instruction requested?
I'm sorry, what would you ask?
An instruction that the strength of the ID doesn't necessarily indicate that the recognition is more valid. Was that instruction requested?
The defendant requested in his written instructions an instruction that there was no proven correlation between competence and accuracy.
And what was the judge's reason for not giving that?
The judge did not give that instruction. She indicated that the honest but mistaken ID instruction was sufficient. And I would also submit that there was no evidence submitted in this case. There was no expert testimony offered. There was no evidence of these studies submitted in this case. None of that was before the judge. This modified instruction was also not before the trial judge. And the studies that are cited in the defendant's brief that I cite don't show that there's no correlation. On average, it shows that there's a slight correlation. A slight correlation does not equate to no correlation. And for a judge to instruct a jury that there is no proven correlation essentially strips the jury of its ability to consider that type of testimony for any purpose.
I know you don't have to decide this, but I take it from your argument here that it would have been appropriate for this defendant to have asked for and been permitted to introduce expert evidence on the strength of ID.
Perhaps, and I temper that answer with, I believe that the expert testimony would need to be tied into the facts of this identification. And one of the issues is the familiarity of the victim. And so if an expert comes and offers testimony based on this and based on the facts of the case, because it's not just one factor alone in any identification. It's in terms of an identification, how familiar is the person with the individual? And most of the studies that are done in this area are typically done in voice lineup situations. Very few of these studies, if any, cite an individual where a person recognizes the voice. Usually it's problems with suggestive IDs.
No, but
you're
confusing voice and photo IDs.
No, you're asking me, the jury instruction was specifically about the voice ID and the accuracy thereof. And that was what the testimony was of Mr. Patel in this case. In the defense instruction,
well, should the prosecutor have been allowed to argue that in essence, you heard the witness, he was absolutely certain about this? Was that an appropriate argument?
Yes, it was appropriate. It's been held to be appropriate by the appellate courts. The defendant didn't challenge that below in terms of, it doesn't challenge on appeal that this is a proper argument for the parties or that it's a proper subject of argument, yet then says that an instruction should be given that there's no correlation, while at the same time arguing that it's still proper for the sides to argue that, which I would submit is inconsistent. And I would also submit that it would be, in terms of giving just this one instruction, which explains a purported impact, even if it's some type of modified instruction, focuses on just one aspect.
Can I interrupt you? If a defendant came forward with an expert to talk about the reliability or validity of an identification, whether it be voice or visual, would a judge have to hold a Daubert hearing on this expert and determine whether the so-called science of this thing is?
I believe that he would, Your Honor. I mean, at least on the record here, I'm obviously not an expert.
So here there was no expert offered, number one, correct? And obviously, since none was offered, no Daubert hearing.
Correct.
So this backs the defendant 2 steps away from what he's looking for.
Correct. Correct. That's part of my
I
argument.
mean,
think.
unless we're supposed to take judicial notice of these articles that are here and there, which I
No,
assume you would say we're not.
No, I would argue that you should not. Even the 2 articles cited, if the court reads the text of them, they're essentially a summation of what these authors believe the studies have said, and we don't have the specific studies, what groups were these studied on, how they define these terms, and things like that, which is exactly why I think expert testimony would be the more appropriate realm for this area, and then it ties it in the specifics with the case, because even if you have something that's true average in terms of statistically, that doesn't make something true in every case. I mean, just as an analogy, if the average home price in Boston is $350,000, that doesn't mean that every person that buys a house in the Boston area pays that amount. Similarly, if the average correlation, for instance, which in one of the articles says 0.25, that doesn't mean that that's the case in every single case, and there's lots of factors that come into play with identification testimony, and I would submit that that is part of the reason why this instruction is inappropriate, and it also focuses on one single factor to the exclusion of others. And for those reasons, if there's no further questions, I will rest on my brief for the remainder of the arguments.
Thank you, Ms.
Thank you.
Grant.
May I make one request?
Yes,
Would
Mr.
the court be interested in a 16L letter with some citations to published articles regarding the correlation?
You may certainly submit one. I'm not going to rule for the court that we would be interested, Mr. Keene.
Thank you.
Our interest rises with their persuasiveness.
And whether or not they were raised at trial and whether or not they went through a Daubert. Thank you, Ms. Grant.